गुड इवनिंग सर. गुड
गुड
इवनिंग
इवनिंग
सर.
सर.
गुड इवनिंग सर.
नमस्ते सर. कैसे हैं?
बस सब ठीक. ऑल गुड.
All good. Great sir. We are YouTube live sir.
Subramani sir.
Good
Good
sir.
evening.
Good evening,
Hello
sir.
sir. Good evening sir.
Good evening.
Thanks for joining.
Good evening.
How come, sir? Sudhakar, sir.
Thanks for join பண்ண விட்டுட்டேங்கிறதுக்காக join பண்றேன். அவ்வளவுதான்.
Welcome, welcome.
join பண்ணி disappear ஆயிருக்கு. number
Welcome.
கூட்டிட்டு போயிருவேன்.
Welcome, welcome. Sir, this is Hemant sir. This is Dr.
Okay.
Sudhakar, our president-elect
Oh,
of Hemant sir is the first speaker.
sir, good evening sir.
Good evening sir. Good evening sir.
Good evening sir. தெரியலையே. Not
He's
visible.
from
Sir, good evening. How are you
Good
sir?
evening all sir. Good evening.
Good evening
Sudhakar
sir.
sir, Prasanna sir, good evening.
Good evening sir.
Hello,
Good
sir.
evening.
Good evening.
Vasuntaram sir, good evening. Hemant
Good
sir,
evening,
good
sir.
evening.
Good evening sir.
Good evening everyone.
Good evening sir.
Sir.
Devendra sir, daily we are seeing you are getting some award.
Yes sir, sir.
Very proud of your service, continuing service.
Thank you sir, thank you so much. Best wishes and blessings of all sir.
Thank you.
Because of that I am able to do.
Yes.
Thank you sir, thank you very much. कर दिया join इसमें. मैं एक बार कर लेता हूँ इसमें. ऊपर कर लेता हूँ इसको. ये लो. ये रहा.
Good evening Yamuna ma'am.
क्या चाहिए?
Gmail.
हैं?
Gmail sir.
Okay. क्या ये इधर चाहिए क्या? इधर करना है.
How many members are there in this city branch? Total?
Sir?
How many members are there?
We are around 1300 sir.
1300. अरे वाह.
बस तो नहीं चाहिए.
सर मैं देख रहा हूँ.
We will wait for 5 minutes, sir, and then.
We will
No
start.
problem. No problem. As you order,
Just
sir.
putting.
No problem. How is the climate and temperature over there?
Sizzling hot,
Ah,
sir.
Okay.
Where,
Sizzling hot.
sir?
Climate and temperature over Chennai.
Temperature, sir. Pleasant. Evenings are pleasant. Morning is also pleasant.
Okay.
No woolen required, but not warm at all. Comfortable, very comfortable, sir.
Okay.
And Udaipur is really surrounded by the lakes, na. So
Ah,
temperature is always maintained here very well, very comfortable always. Today we are discussing very important point, sir. This is medical legal is very important, sir. Yes.
yeah.
These are online meetings are very important. I remember when Dr. Basavaraja 2021, I was EB member that time when he was the HSG. So we had
Yeah. Yes.
most of them were online, na. So
Yeah. Yeah.
we are just talking to each other, sitting in front, na.
Yeah.
From the COVID time, then the concept of the online meetings came.
COVID made us use this
Yeah, 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 yeah.
technical and eco-friendly.
Definitely, definitely, definitely.
We were not aware of the Zoom, but Zoom is used so for so many years by corporates. We were not aware of that.
Yes, sir. And this is most comfortable time for the online because we are free from the patients also, na, this time.
Yes.
Yeah, this is most convenient. Yeah. Madam Bela Verma has also joined.
Yeah, good evening.
Good evening, madam.
good evening, madam.
Good evening, ma'am.
Good evening, everyone.
Good evening, madam.
She delivered a wonderful talk on tuberculosis today. Wonderful, mind blowing. Yes, Bela
This
madam.
is my
In
second
the
webinar
afternoon.
today. I spoke for IP Palghar on TB infection or latent TB.
Okay, okay.
Actually, the initial part, 5 to 10 minutes, they are the friendship parts, no? We can talk to each
Fellowship.
other. We see, talk to each other like that. Na? So that is one of the most enjoyable moments.
First 5 to 10 minutes of webinar should be fellowship now.
Yeah, very true. This is very true. Initial 5 to 10 minutes are like the fellowship, no? In our Rotary also, there is a fellowship before that, and that is also one of the most enjoyable part.
Yes.
Sir, Som sir, I think many people have joined through YouTube. I think it's better we start.
Yeah, yeah. YouTube viewing is there now. Yes. So shall we start, sir?
Yes, yes. Dr. Hemant, can we start?
Yes. Yes, no problem. No issue.
So, on behalf of IAPCCB, I take it as a big honor to welcome you all for this um, webinar on medical legal aspects of our practice. So, with us are two very senior, well-read and knowledgeable faculties. The first is Dr. Hemant R. Gangolia. Sir has been the president of the Maharashtra Academy of Pediatrics state in 2022. Sir is also the scientific committee convener of the IAP Medical Legal Group 2023-25. Sir is from Raigarh. He's a practicing pediatrician and also medical legal consultant. Welcome, sir, to join us in Chennai with us at Chennai IAPCCB. It is indeed a great honor to have you along with us.
Thank you. Thank you, sir. Thank you, sir.
Also with us is Dr. Bela Verma, ma'am from Mumbai. Ma'am is from Grand Government Medical College. Ma'am is also has also been an EB member of West Zone of the Medicolegal chapter and has been, I think, looking into the medical legal aspects of our practice a lot. Ma'am is a professor and head of pediatrics in the medical college. Welcome, ma'am. Thanks for joining us in the late evening. It's indeed a pleasure to have you with us. Without much of ado, can I ask our president, Dr. Somasundaram, to say a few words, and then we can proceed with the scientific program. Sir?
Yeah. So thank you, Dr. Subramaniam, sir, for initiating the meeting. So this is an what I say is this is to commemorate the IAP Medico-Legal Awareness Protection Day for doctors. So we wanted to have a webinar to create awareness among our IAP members. So this is one among the activities of Chennai City branch. For this, thank you, Dr. Hemant sir and Bela madam for accepting our invite and be with us to share your knowledge so that our medical our pediatricians right will be they will be protected. And without wasting my time, I invite Dr. Hemant sir to to present on the basics of medico-legal issues. Welcome, sir.
Thank you very much, sir. I will just share my slides. So are you able to see the
Yes,
slides?
sir. Yes,
Yeah,
sir.
yeah, yeah.
Yes,
It's
sir.
visible, sir.
As well as I'm audible.
Yes,
Yes,
sir.
sir.
Good evening to each one and all, respected office bearers of IIP Chennai City branch under the dynamic leadership of President Dr. Som Sundaram sir, as well as Secretary Dr. Subramanian and Treasurer Dr. Nisha madam, as well as I see Dr. Devendra sir present over here, and all other dignitaries who are also my co-faculty, Dr. Bela Verma madam. I could see Dr. Yamuna madam, Dr. Neha madam on this Zoom platform. So good evening to each one and all. And at the outset, let me say namaste to each one and all. And I'm really thankful, Dr. Som Sundaram sir, to invite me for this webinar. And hope so my talk will benefit to each one and all. So the topic we are discussing today is basics of medical legal issues. This is the most important line. 1 minute, huh? This is why not going. So the most important line, what is this is Latin maxim of law books. I didn't knew the law, hence I should be excused. Ignorance of law is not the excuse, probably everybody knows. But what I want to say is that there are lots of gray areas. Medical legal issues are part and parcel of one's practice. One has to accept it, and one need not get afraid of it. One should think of the way outs. One has to redefine, retrospect one's own practice in this era of consumerism. We should not go towards lot of defensive practice, but to what we can make the way out of that is very important. Every patient we should think as a potent litigant, but to be watchful. And if any complication occurs, we should save the papers for lifelong. What we used to practice 25, 30 years back is not possible today, as most of the seniors who are attending the webinar, they will be able to say this. There are some case laws which has brought the change over the years, and therefore faith has been replaced by contract. One has to change with time. Mishaps are the part and parcel of our practice. We have to accept it and face it. But then we should learn and get mentally prepared to face these things in our practice in our medical practice. So what are this? I will just sense it. I will not go in the detail of the case laws, but these case laws have really changed our practice, what we used to do 20, 25 years back. IMA versus VP Shanta case law has brought medical profession in ambit of consumer. Permanent Katra versus Union case law states we don't have right to choose the patient in emergency state, but in non-emergency state we can choose our patient. What this implies, if any emergency come, with whatever ability, capacity, limitation, infrastructure we have, we should manage the patient, and if not, then transfer in appropriate vehicle with appropriate person in appropriate way with appropriate medicines and emergency drugs. That is what Parman Katra versus Union case law says. Prabha Manchanda case law is all related to consents. We will come on that. Everything, whatever consents came, it came through this case law. Hiranandani Hospital case law states that dead body cannot be held against pending bill. This is very important judgment. Any judgment comes with reasoning. There were 3 wrongs involved here: moral wrong, legal wrong, ethical wrong. So, as we have alternative remedy to have our bill, so we cannot hold dead body against the pending bill, because moral and ethical wrong is morally and ethically is more important than the pending bill. This is a very important case law of V. Krishna Kumar versus State of Tamil Nadu and others. This is 1.8 crore compensation case law where there was lack of documentation of retinopathy of prematurity. On discharge card, appropriate follow was not mentioned, and this patient went through Chennai, Mumbai, then went to US and had the case filed, and this was a compensation given. So documentation is very important. And this 1 crore Prashant Dharanka versus Nizam Institute Hyderabad case law. This is all related to cross specialty practice. The message by this case law is that we should stick to our specialty. We should not encroach our specialty. Whatever specialty that we have, we should practice accordingly. So these are the important 6 case laws. Therefore, as always said, prevention is always better than cure. And I always say these 6 words, which are very important while practicing in our medical practice. The number 1 word is anticipation. We should always, whatever we practice OPD or indoor, whenever the emergency patient comes, unexpected, complicated things are there, we should be able to anticipate, and we should have some plan in the mind ready. Suppose this thing happens, what I'm going to do. That makes our life a little bit easier. The second most important, this is the only word which is very important in medical negligence, documentation. The documentation should be justified one and informed one. The third word is very important, which is communication. And communication is an art. Actually, we learn as we practice. The communication, one line to be attached to communication, that whatever we communicate, it should be informed, documented communication. Then 4th word is limitation. We should always practice as per our qualification, infrastructure, ability, and capacity wise. 5th word is follow the principle of ethics. There are 4 principle of ethics: respect, do good, do no harm, and equality. And it's not possible to achieve 100%, but at least whatever maximum we can practice, we should practice ethically. And last word, which I think so is almost important at the end of the day, whenever we should learn to audit our prescriptions, and the word is introspection. We should introspect our prescriptions by keeping our near and dear ones in the shoes of the patient, and we should decide what I have prescribed, what I have treatment given, whether it will be right or wrong. So these 6 words, if we imply, probably our life will be easier. And going ahead, the one word by word, document is very important. Case paper is an important paper. Always we should mention the history of drug allergies or the negative or positive, whatever may be. Always we should follow the thought process. Complaint of on examination impression. We should always be, because there may be DDs at that point of time. So, example, day 5 of the fever, then cough cold is there, fever is there, and if you write that's on that day, it may look viral, and if you write impression viral fever, then our prescription what follows should show that it should resemble our thought process. If we write viral URI, and if we are writing next line amoxicillin, that is become the gross negligence. So whatever you write impression, we should have. And same fever may turn out to be on day 11 or day 12 as an enteric fever. because it may happen. So the thought process at that time is very important. So whatever you write on OPD paper is very important. Whereas in admission paper, avoid writing city hall. And if seniors are involved, they should write something instead of city hall. Own handwriting shows that the patient has been seen by the seniors. Discharge summary is Xerox checked by senior one, and computerization can make things easier. The documentation, what we see, we should write. What we examine, we should write. What we advise, we should write. What we are advising, that also we should write. So everything should be written, documentation. And documentation becomes much more important in some cases of scenarios like anaphylaxis, sudden death, table death. And in these such cases, it's very important to write the resuscitative measures. And sometimes at consultant level also, we get fumbled to write the resuscitative measure in proper order, in proper sequence, in proper chronology. So rehearsal is very important. And why the writing is important in this case law? Because if the police gets involved in this, originals are seized. And we are still poor at it. Hence, we are reluctant to call police at first instance. Therefore, we should learn how to document in such scenarios. Why documentation is very important? It is the only evidence which is court of law relies on documentation. The important word, documentation, is only thing which is the good defense, the only strongest defense in the court of law. Court of law relies on documentation. Good justified documentation is important. The important things, what we inform has to be documented, as what we communicate verbally has also to be documented, preferably in the language the patient understands, and the documentation should be with justification and time one, so that if summoned by court of law, we should be able to justify. Writing, after everybody knows, we should write probably in a writing which is legible handwriting. So the final word of documentation, justified, informed document, well timed. This is all about documentation. Anticipation is very important word. This is high time we should learn to anticipate the ringing bell of probable violence in probable scenarios. I will come to the scenarios, as anticipation makes us mentally prepared how to go about in such scenarios. Communication is an art. It's a very important. One has to acquire the skill of communication. Mostly important in the declaring, the sharing the bad news, explaining the seriousness prognosis, day-to-day status of serious patient, pros and cons of the treatment option. And surely seniors have to get involved and not juniors, mostly in the these deaths and these things. So communication is an art, and this breaking bad news is very important, and spikes protocol to be as fast can be possible. Consent is very important. Any line about consent, any invasive procedure, we should take consent. Indoor papers and negative consent is very important. Negative consent is equally important, but to mention date and specific time of it. For example, high-grade fever. If the patient refuses to do lumbar puncture, we should mention it. We should write it. And in the time course, if he gets agree, then we can write again. Okay, now the patient is ready to do. So, but whatever is declined, we should write. So, but in pediatrics, the vaccination consent will be proxy informed express consent. I will come on that. The proper format of consent should be there. This is a little bit controversial statement regarding vaccination consent, because as one of our UMP module states, first slide of the UMP module states, the vaccination implied consent. Yes, it is done. But now, when Japanese encephalitis in our Maharashtra state is given in 3 districts, we are taking the consents. The government also taking the consent for giving Japanese encephalitis vaccine. So probably the line may be, to save our own skin, one should take the consent in all the invasive procedures. That is the important line. Types of consent, I will just go these are types of consent which are the implied verbal. Then this is express written, whatever we take in the writing is expressed. Proxy is the consent given by guardian in case of minor, unconscious, mentally incapable. So the word regarding consent should be informed, express, written, documented communication. And BNS defines the age of child as 18 years. So appropriate format of consent one should use. There are many firms who give the proper format of consent one should take. Otherwise, as in our branch also, there are so many consent form in the textbooks, we can take and we can modify, we can individualize for ourselves, and can use for the consent time. But one word again, types of in admissions, the first day paper, admission paper, is a blanket consent. Suppose that is important. We have to take the consent for admission. But suppose if the guest same high grade fever, and on day 3 if we are deciding to do lumbar puncture, so that day we should take real time consent in the language which patient understands and should be taken in that time. So what is informed valid consent? The ideal consent I will speak on in the language which patient understand, in writing, reasonably detailed, simple language, duly signed by the parties, and should be well timed, and is not legally valid if given by incompetent person like minor, mental incapable, intoxicated, obtained by fraud, misrepresentation, and by undue influence. So that is invalid, but the valid consent is much more important. The important papers in our practice, which are very important. The first paper is OPD paper. OPD paper should mention the name, our qualification as per National Medical Commission guidelines. If you have done some fellowship and everything extra fellowships or the certificate course, we can mention, but they are not, we should not claim to be specialists in that branch, but we can mention that done fellowship or done certificate course in that, that can be mentioned. That will not come under qualification. Qualification will the qualification which is recognized by National Medical Commission. And so proper OPD paper format should be there. Three papers are very important: indoor papers, TPR, and input-output papers, and nursing treatment papers. Whatever consultants write, whatever the orders are written in the indoor paper, has to corroborate with the treatment given by the nursing staff, as well as the findings which are written by the doctor on the indoor paper should corroborate with the findings of the nursing charts. And this should always corroborate. For example, if one is writing temperature of 102 and pulse of 92, it doesn't corroborate. Accordingly, it should corroborate. So what the important line, thought process, these three papers should corroborate clear follow-up instructions, not ticking, but writing the things, appropriate papers, and transfer mode should be written properly. The other important papers, the discharge paper with follow-up instructions and transfer and referral papers. Regarding discharge papers with follow-up instruction, we already seen the this Krishna Kumar versus Tamil Nadu case law, where the in discharge paper follow for retinopathy of premature was not mentioned. So follow-up instruction should be clearer. Transfer referral papers very important. Whenever one transfers the paper, one should communicate with the hospital where we are transferring, and according to transfer. If the serious patient is there, better to doctor should accompany the patient, and in case of very sick patient, we can inform the police also. So we are transferring serious patient. On the way something happens, it is always beneficial that we are transferring patient in such a status. So, and various certificates. So in practice, we issue so many certificates. Important are the treatment, sickness certificate, and then so many certificates are there. Then death certificate. The only one line regarding certificate, we should use proper formats of the certificate that are given in the NMC guideline. But what the important line is, whenever one issues a certificate, one should, whenever issue the certificate, should be able to justify that document if summoned by the court of law in case of any litigation. That is important. Same thing holds true for death certificate. If you are writing cause of death, be sure if you are called by the court of law, you should be able to justify your document what you have submit, what you have given to the patient. So these things are important regarding the certificate. So all in documentation, these all papers, the one word, the important word is justification. Whatever one writes, it should come with justification. That is the important word. So this is the NMC guideline number 2, which mentions how this should be the prescription format. We will not go in the detail. One can just go and see the things. This slide I have taken just to show that if any patient asks for the papers from us for our records, it should be taken in the application form, and the responsible person from the patient side should apply. And we should be able to give these records within 72 hours as stated by the MCI guidelines. Still, NMC is at abeyance. So whenever NMC gets implemented, we will get 5 days, 5 working days to give the records. So this is the 5 working days to give the record. But once NMC gets implemented, each registered medical practice should have to make the computerization, and then it should begin. One more important of this slide is that the medical records of any inpatient for 3 years from the date of lost contact with the patient for treatment. This is just for information. So we have to give them. What is medical negligence? We will not go in the definition, but a simple, it involves the acts of omission and act of commission. A prudent, reasonable doctor with an average skill. But as the specialty goes, the responsibility increases, the skill also increases. As per the standard protocols, as per the standard textbooks, while treating the patient doesn't do the act which was necessary while treating the patient is an act of omission, but does the act which shouldn't have been done while treating the patient is an act of commission. So it all revolves around the omission and commission. And while doing that, these are the essential of negligence, which is defined by the 4 Ds. Whenever we see the patient, the duty arises towards our patient, and any deficiency in this duty which directly results in damages, which may be in physical, mental, or financial to patients or relatives. These are the essentials of the negligence which is to be proved by the complainant or the litigant. So for just we will go hurriedly on acts of omission. Some of the examples are failure to advise hospitalization, not attending patients, not obtaining proper consent, not taking proper precautions. These are all act of omission. Act of commission, caring beyond one's skill, faulty technique, overdoses, wrong drug, leaving swabs, instruments, answers. So these are the act of commission, wrong reports. So these are the act of commission. So types of negligence, there are 3 types of negligence. One is composite, the another is contributory, third is corporate, which is corporate means is a vicarious, not related to corporate hospital, but it is a vicarious responsibility which is said. So we will just go one by one. Composite negligence is the negligence where the harm is contributed by 2 or more. We will just give the example. In this case, example, that was the harm contributed by 3%. So orthopedic surgeon 30%, anesthesia 60%, cardiac 10%. One more case law where instead of asthma medicine, diabetes medicine were prescribed, which called the hypoglycemia, brain injury, compensation doctor was 25%, chemist was 75%. This was all because of illegible prescription. So harm contributed by 2 or more is known as composite negligence. Contributory negligence is the related to undesirable or negligent act of the patient. This is a good defense of the doctor failed to take ordinary care, explained all, and patient changed the dose, time, mode without considering doctor. So this is all related to the good defense for doctor. Types of negligence, the examples of contributory negligence in the hysterectomy which was done, had the infection because didn't follow the instruction. Extra dose of steroids was taken 3 months without contacting doctor, which caused disability. So this is the contributory negligence of part of the patient, which is very good defense for the doctor in the court of law. Corporate negligence is whenever the hospital authority is vicariously liable for negligence and its employed person. So in the settings where we have the juniors, where we have the housemans, and where the RMOs working. So for any act of them or the nurses, if individual settings where the nurses staff is there, for any negligence caused by them, we are also vicariously liable for that. That is known as vicarious responsibility. So there are many examples of this corporate negligence, case laws of vicarious liability. I will just tell 1 or 2. This is Spring Meadows Hospital case law where instead of chloramphenicol, which was to be given IV in the case of enteric fever, the chloroquine was given, which caused the severe brain damage, and so that was the illegible prescription, and that is the case of vicarious liability. One more case law is this sponge left in the abdomen during the cesarean operation. Death after orthopedic operation on hip unattended post-operatively. So these are the case laws related to the vicarious liability, vicarious responsibility. The important 2 principles, 2 words, most of you must have heard about this, Bolam and Bolito principle. These are both legal concepts used to assess professional negligence, especially in the field of medicine. But just to highlight what is these principles, one should know. Bolam versus Fried Hospital Management Committee. In this case law, this focuses on whether a professional actions are supported by a responsible body of peers within their field, and if a body of professionals deem the actions perceptible, the profession is not considered negligent. Suppose there are 2 or 3 alternate forms of treatment available, and one follows whatever the peers follow, then there is no negligence. This is applied in the Jacob Matthew case law, Suresh Gupta case law, and others too. The Bolito versus City and Hackney Health Authority case law, it adds an additional requirement that the professional opinion must also be reasonable and logical. Though it is practiced, this allows the court to reject a professional opinion if it does not withstand the logical scrutiny, even if peers support it. So what is the key difference between two principles? Bolam principle relies primarily on peer support to establish the standard of care, and Bolito principle ensures that this standard is not blindly accepted, but it introduces judicial oversight to ensure that the opinion is not just supported by peers, but is also rational and defensible. So Bolito principle can be said as a defined the Bolam test. So it makes making negligence assessment more robust and fair. So one should be aware of these two principles. So what are the legal forums? Suppose if any mishaps happen, if anything happens on our side, so what are the options available for doctors to go? These are the four options: informing police, calling your colleagues, and calling influencing persons, and financial settlement. Always informing police is the best option. Colleagues are important. They should come for the help. But one more thing about financial settlement. Doctors want to get rid of the problem as soon as possible. Hence, most of them resort to this. But this trend is an invitation for them all that time. 1 minute. So, regarding financial settlement, there's a Supreme Court of India ruling. Do not give any cash or check to the patient in an out-of-court settlement without proper written agreement. That term is consent terms. So informing police, so we should have a rapport with the police station. For patients, there are so many forums available. If they need litigation they want to do, they can go to police station, they can go to criminal courts, they can go to consumer forums, they can go to medical councils, they can go to National Human Rights Commission, civil courts, other authorities also as Chief Medical Officer, Ministry of Health, Lok Adalat. Why I mentioned this, the most important point is in case of FIR, if patient goes to police, we do not have time, hence we should learn appropriate documentation. In all other forums, maybe criminal, maybe consumer, maybe medical council, maybe civil, we get the notice, and this notice has to be replied within 30 days. And extension we can get for more 15 days. So we do have time to make our reply in written statements in proper order to submit. But in case of police station, where there's FIR, we don't have any time to make papers. Hence, one should learn the proper documentation. And of course, whenever we reply to any notice received from any forum, we should take the help of good criminal lawyer as well as a good medical legal expert who can guide criminal lawyer to write the reply appropriately. So one should remember this thing, which is very important. Burden of proof is always on complainant. In criminal, to be proved beyond doubt. In civil, it's a balance of probabilities. Sometimes burden of proof shifts to the defendant. The line is known as res ipsa loquitur. That is, thing speaks for itself. Facts are so clear, leaving an instrument sponge operated on wrong side. So what is the section for this medical negligence? Just 1 or 2 lines on this, because Madam Bella Madam would be covering BNS. Initially, when the Indian Penal Code was there, they used to apply 304A for any case of medical negligence. And what was the punishment? Imprisonment of either description for a term which may extend to 2 years, or with fine, or with both. Whereas now it is BNS 1061 is applicable, where punishment is the imprisonment of either description for term which may extend 2 years and shall also be liable to fine. So here the word or is replaced with and. So the punishment as well as the fine is there. And for the first time, medical negligence is defined in the BNS. Personally, I feel IPC was good than BNS. These slides we will just skip because there are so many defenses of doctor against the charges of negligence. There is a long list of that. This we will just keep on this. And so difference of opinion, wrong diagnosis, error of judgment, precautionary measures. Again, the long list of precautionary measures is there. One should just read. I may share this PDF file to the president, sir, and he may circulate in your group. No issue for that. So but though this is a long list of precautionary measures, whatever precautions we take, sometimes or other, something remains. But that something remaining should not be a gross negligent ones. It should be so we should take care of this, all precaution measures regarding this. The most important last line, death certificates to be issued very carefully in deserving cases. These are the scenarios where in the practice which are the related to sudden death and trigger factors for mob violence and litigation. At clinic following injection, which is known as anaphylaxis, emergency patient coming gastric stage and dies, sudden death in hospitalized patient while treating the patient, the hospital setup, broad death at the clinic, hospital. So these are the scenarios where one should learn how to approach this case. Table death is one important. We should be know this VIP syndrome as well as to be careful of 5 Ps. I always say they are the politician, press, professor, police, and lawyers or prosecutors. So they are in hurry, so we can just make the adjustment for them, but just we should not keep our ego high. And these are the cases where we should learn how to go through and the things. These are the trigger factor for mob violence. So in anaphylaxis, important still the drug everybody knows because this is a learned audience attending this webinar. So adrenaline is the drug of choice for anaphylaxis. But many times at the peripheral rural setting, at individual settings, we do not find adrenaline, and then the issue happens. Always adrenaline should be available. Which I will not go in the treatment of anaphylaxis. Everybody knows with that. If ABC not done, then it can cause death. And in case of anaphylaxis, probably the best option informing police. But before informing police, one should do the documentation. Clinic notes must be written. What injection, sequence of event, resuscitative measures, preserve all the used empty, half empty vials as it is, oxygen cylinder, masks, and everything. The message from this is that in office practice also we should keep the oxygen cylinder, emergency measures, emergency treatment, medicines in office practice also, because if anything happens, if you have not managed as per the standard resuscitation measure, that is a gross negligence. But if you have managed and in spite of that death has occurred, then it is not a gross negligence. So we should ampule of adrenaline. This is my age-old side of since 2010. So adrenaline should be keep worries of anaphylaxis away. The important case laws one should always know, they are dynamic changes with time and upcoming judgment. But still, 4 case laws are very important, which is used for the defense. Just I will rush through it. Important case law. Everybody knows this. Martin D'Souza case law. One should read this all judgment word by word. Very important thing. The important message from this Martin D'Souza case law, which is not to arrest doctor, not to harass doctors, and refer to the committee of doctors. This is very important. Police stations are not aware of that. We should have this copy of judgment in our mobile. We can shoot to them. And this paragraph 117 all define whatever I spoke about it. And this is to be referred to the committee of doctors. So therefore, this judgment came on 17th February 2009, and therefore in 2024, with the efforts of the then chairperson of Dr. J.K. Gupta sir and secretary Dr. Satish Sharma, who was vice president of North Zone that time, we came out with this Medico-Legal Protection Day for doctors. 17th February celebrated. 2024 it started, in 2025 it was in a big way we have celebrated this. So this is the day, Medical Legal Protection Day for doctors celebrated. And on this occasion, Indian Academy of Pediatrics came with a circular to all the president secretaries of IIP state, district, local branches. Most of them have gone through by organizing. The theme was medical legal protection, a doctor's right of patient benefits. Slogan was legal knowledge, safe practice, shielding doctors strong and active. And, and what are the activities can be done? Organizing press conference, giving representation to top police officials, arrange workshop, and activity doctors school of awareness of the POXO Act. So this was the beautiful memorandum which was by email. Most of them you have received. This has to be submitted to all police station as well as office of IG. This was drafted by Dr. Mahesh Baldava sir, Dr. J.K. Gupta, supported by Dr. Satish Sharma, and this includes key directives from these judgments to be followed by the police officers. This was the press release in English. This will not go in the detail. This was press release in Hindi. So same in your language at Tamil Nadu, you can just draft this thing and just can submit in the press and can submit to the police stations also. So another case law is very important. Jacob Matthew important case. Here, onus of proving negligence is on complainant as well as reasonable degree of skill and knowledge is standard care is defined by this Jacob Matthew case law. Suresh Gupta case law says any careless act is criminal only if gross inaction or gross incompletion. Death due to error of judgment or accident should not be taken as criminal liability. This is important. Kusum Sharma versus Batra case law. This laid down the principle for determining the medical negligence. And what we see in the WhatsApp, the say Supreme Court decides 11 points. These all 11 points of the narrating about the negligence principles of deciding came from this Kusum Sharma versus Batra case law. There are so many case laws related to expert witness. The one line to say about expert witness is important whenever we approach in the consumer forum. This is very important to them. Crux of all relevant case law is standard care, reasonable skill and care. Error or judgment is not a gross negligence. Expert witness is important. What is new law in Bharat or India? I will just rush to these slides because Dr. Bela Madam will cover this. Indian Penal Code is replaced by Bharatiya Nyaya Sanhita 2023. Indian Evidence Act 1872 has been replaced by Bharatiya Sakshya Adhiniyam 2023. Code of Criminal Procedure 1882 has been replaced by Bharatiya Nagrik Suraksha Sanhita 2023. All this came on Doctor's Day of 1st July 2023. And these are the links where you can get the replacement for the old section by the new section. I will share this PDF. You can just tap the link and you can just get the thing. These all links are courtesy Poonam Khatri, advocate at Delhi Bar Association 30,000 Court. So in short, Bharatiya Nyaya Sanhita has replaced the Indian Penal Code. This is an important link to get the replacement. Most important link is this. Tap the section to get the details of the respective section. Tap the flag for language. You get the information, the 11 languages in this. And now some of the how to make use of these BNS. So these are the sections which are related to the medical profession, which are related to the good faith. I will not read in the detail, but had to highlight Section 211, 18, 19, 25, 26, 27, 28, 30, 31 are related to good faith with consent, without consent, less harm, and communication done in the good faith. One should remember these sections. These are the section 88, 89, 90, 91, 92, 94 related to miscarriage and newborn death. So one should remember these things. There are sections 228, 234 to 335 related to certificates, fitness, false, fabrication, destruction, omission, medical certificate, and fitness certificate. Then 127, 126 sections are related to wrongful confinement or restraint. Patient cannot be detained on the grounds of non-payment of the bill. Then these 271, 273 are related to infectious disease and the quarantine rule. 276, 277 are related to adulteration of drugs, and 63 and 70 BNS section are related to sexual offences where intercourse by any member of management or staff of hospital with anyone in that hospital. These sections can be applied. So we should be just aware of. Section 34 to 44 of BNS are all related to right of private defense. So we can act in our defense also. So these are the sections related to this. Cause of violence is a multifactorial. We will not go in detail to highlight few. Inadequate care by hospital staff, emergency not managed properly, high volume of patient load, understaffed emergency, and billing is the most important cause in sudden death. Poor communication is one of the practical tips. There are preventive measures and action measures. And for this, there are few important. I will just go. Design of our workplace. There should be always an emergency exit. Emergency room should be well equipped. Doctor Protection Act should be displayed. CCTV important. And in action measures, if any mishap happens, take photographs of the damage done to the property, medical check of injured, MLC should be done, register FIR, which is very important, inform police and call your colleagues immediately, important action measures. And now, this is again, Dr. Bela Madam will be highlighting, these are the crimes which are mentioned here, use of abusive language, misbehavior with doctors, causing injury, hurt to doctor medical, threat to doctor medical. This section, we should remember BNS section involving all these crimes which is mentioned as an offense. Attack on government doctor, government medical staff, forcefully stopping government doctor from doing his duty, damage to hospital property equipment, wrong defamatory news. Again, the corresponding BNS section can be used while doing the FIR. One should just have a knowledge about it. And mob attack, forceful entry into the hospital, attack, harassment to lady doctor. Again, these relevant BNS sections can be applied in the FIR. So what is important? This section one should know that it can be done. Why I am mentioning this? I will just in 1 or 2 minutes. Doctor Protection Act is very important. It is implemented almost 23 states. In Tamil Nadu, what is stated, you should be aware of that. And this the Doctor Protection Act, everyone should have in this copy of in their mobile phone, because even police stations sometimes are not aware of it. So one should be able to show. One can do this. We have displayed in this in Marathi. We have displayed in clinic in the hospital in our Raigad district, Karjat Taluka. We have taken the permission from the police station and we have displayed this. This any whatever the doctor protection at any of the states involves 4 sections important. Section 3, act causing damage, loss of violence is prohibited. Section 4, punishment imprisonment up to 3 years and fine up to 50,000. Section 5, offense is cognizable, non-bailable, tried by first-class judicial magistrate. Section 6 is compensation twice the amount of the damage. So these all whatever I said, violence and related BNS section and Doctor Protection Act, we should display in our clinical establishments. So this is the which I have prepared in this year only in month of January. I will share this. This can be displayed at all in our branch clinical establishment. You can mention your branch name also, and just you can just frame it this thing. And this is a Doctor Protection Act again, which we have displayed. This is of Maharashtra. So similarly, on same lines with state of Tamil Nadu, you can just mention. So display of Doctor Protection Act, display of BNS violence should be displayed. This is Marathi. This is English. And why I have said this all this, because if whenever we do FIR is always done under the acts and the section. And when it is done, this is one of the FIR which we did at our place. So we did this FIR under the Doctor Protection Act, which is related to Maharashtra. Similarly, things apply for Tamil Nadu. So, and when the charge sheet is filed, again, whenever charge sheet is filed after 60 days of investigation, it is also again done in the form under the acts and the section. So again, this act should come, and this sections, related sections, BNS, whatever I stated, can come in here. Last few slides, practical hint number 7, we should be member of local association. We should form long, strong groups. Most important, we should have a rapport with local police station. We should have a courtesy meeting. Suppose your branch has changed office bearers, president, secretary, have a visit to a nearby police station. Just give a courtesy meeting and just introduce ourselves. This brings a rapport with the local police station. And we should always have the good criminal lawyer, excellent medical legal expert backup. At the association level, at a branch level, we can think of keeping all this good criminal lawyer as well as the courtesy meeting with the police station. Any mishap or litigation may be happening, please discuss issue immediately. Research the literature. What are the literature for? What is against? Preserve the papers and appropriate documentation. Why I said so? Because there's period of limitation act which says after the incidents, for the period of 2 years, patient can go at any forum to file the complaint. And that time we receive notice, we don't remember what has been done. So always, whenever any mishap or any interest litigation, any complication, please preserve those papers lifelong and research the literature. Keep everything ready with that. Suppose if any notice comes, we should be able to reply that. So that is the important line for that. And of course, this everybody knows, medical jousting, 43% is the single most reason litigation for filing the cases. So we should not criticize our colleague. And with that, probably still I feel this all, whatever the things is era of consumerism there, the bottom line is if we have honesty, transparency, punctuality in our professional practice, we can overcome the stress of our practice. And we should follow those 6 words which I have said, very important one. To summarize, proper documentation is recommended, follow the standard protocols. Standard protocols, I mean standard textbooks and standard things. Guidelines are there. Guidelines are not mandatory to be followed, but they are not mandatory. Mandatory is the standard textbooks. Manage the complication as per standardized recommendation. Keep contents of emergency kit at hand. Oxygen cylinder, laryngoscope, ambu bag must in office practice also. In mishap, police information is always the best option. Call colleagues for help. And mishaps are the part and parcel of our practice. Let us accept it and face it. But one of the surveys still says दिस इन हिंदी। दुनिया में अभी भी सबसे भरोसेमंद पेशा डॉक्टरी है, फिर वैज्ञानिक व टीचर। So first doctor, then scientist, and then the teachers. And insurance is the most important thing. We should have, each and everyone should have insurance. There are a lot of companies giving insurance. To name few, IAP, PAS, AMC, Apex, Doctor. But most important reward regarding insurance, please individualize yourself. Please read terms and condition word by word for you. Please follow the insurance which gives the 1:1 ratio. These things are important. Modify as per individual needs. Do not just go and sign the documents and take the insurance. Please follow read the terms and conditions properly. With that, Swami Vivekananda has said long back, no gadgets has been developed which can predict 100% correct medical prognosis and can assure 100% medical recovery. But with experience, skills, logic, a doctor can try to find the means of treatment to avoid mishap, but with limitation. Each and every time it may not work or will be right. Therefore, doctor should not be treated as God, as well at the same time not to treat doctor as an accused. With that, I end here. Thank you very much.
Thank you very much, sir. That was very, very informative. Lot of practical points, including our day-to-day practice, like your 5 Ps, where, where it should be like in everyone's practice mind when we encounter what is those things. I do have certain questions to be to clear it from you. Before that, let us finish madam's session, and then we will come back to the questions, sir. Is that
Yes.
okay? Yes, sir.
Yes, sir. Yes, sir.
So thank you very much. And if you can stop sharing, yeah. So we will hear to now over to Dr. Bela ma'am. We have already introduced ma'am, and ma'am, can you share now? Yeah. So, ma'am will be sharing the thoughts. What will be the major difference between the IPC and the latest 2023 BNC? What will be the major differences and how that will be useful for our medical profession? What all the take from that? Over to you, ma'am. Thank you.
Yes.
Yeah, good evening, everyone. And yeah, so good evening, and thank you for inviting me, IP Chennai. I'll be speaking on Bharatiya Nyaya Sanhita, which is the latest 2023 laws, versus the Indian Penal Code, which is your previous laws, criminal laws.
Ma'am, 1 minute. Let me mute that person. அவரை கொஞ்சம் மியூட் பண்றீங்களா பாலாவை? நம்ம பாலா தான் மியூட் பண்ணிடலாம். நீங்க
Yeah, shall I share again?
The slides are already there, ma'am. We can hear you.
Okay, wait, I can't see my slides now. What has happened? What did I do? I changed some view.
Oh, really?
Oh,
So you can
what did I do?
unshare and then come back.
Yeah, wait. Wait, I'll stop share 1 minute. Huh?
Yeah, you can stop sharing and then. The equal numbers are there in YouTube also, watching them.
Yeah, so good evening, everyone, and thank you for inviting me today, IP Chennai. I'll be speaking on the Bharatiya Nyaya Sanhita, which is the latest to be implemented on 1st of July 2024, versus the Indian Penal Code, which previously existed. So whether they're a boon or bane for us doctors, what are these new criminal laws which all of us must know? So the learning points would be, what is medical negligence, already covered by Dr. Hemant Gangolia sir in detail. What has changed in the IPC? what are the new criminal laws on prosecution for medical negligence, that the Bharatiya Nyaya Sanhita, and how does it impact the RMP or the registered medical practitioner? So medical negligence, as already known, can be a civil or a criminal complaint, which includes consumer courts. And the various places where a patient can complain to have already been alluded by Dr. Gangulia sir. So by definition, medical negligence is a breach of duty of medical care by a physician or surgeon, which leads to harm or injury to the patient, which can be physical, emotional, or financial. This breach of duty can occur through an act of omission or an act of commission, and the medical negligence can lead to civil or criminal litigation or complaints, including the consumer courts, resulting in legal action against the doctor. So we will see this in little more detail. Now, what do we mean by this act of commission, act of omission? And how are we judged? So how will a code of law judge what a doctor has done is right or wrong? Because everyone has various degrees of skills, experience, knowledge of years. So the benchmark of judgment for any medical negligence case is whether a reasonable standard of care and skill was exercised by the treating RMP. So if it is an MBBS doctor who is treating the patient, for his level of knowledge, skill, experience, did he give adequate care to that patient for the relevant times? The knowledge should not be outdated. He is doing something which used to be done 20 years ago. Not that way. So what is relevant today? So his knowledge should be reasonably updated. He had a reasonable thinking and he did a treatment for the patient. Whether the patient survived or not is not the one which is important matter, but whether he gave adequate care for the patient. So, by the court of law, they judge the conduct of any physician or surgeon, comparing it with that of a hypothetical ordinary man in that situation. What an ordinary doctor would do. Naturally, the higher the skill, higher the degrees, higher is the expectancy for a skill from that doctor. So if it's an MBBS doctor versus an MD doctor versus a DM doctor versus another doctor with more degrees, the reasonable care given by the highest degree has to be much more than what an MBBS doctor would have been given. So that is how we are judged. Negligence is a breach of duty caused by an act of omission, which a reasonable man, guided by those considerations which ordinarily regulate the conduct of human affairs, would do. So suppose there's a dog bite child brought to me in my OPD. I only give injection tetanus toxide and send him away. I know I have to give anti-rabies vaccine or even the monoclonal antibody, which is available now, the patient is affording. And I do not do it, or which a reasonable man would not do, which is an act of commission. That means during surgery, a pair of scissors is left inside, a mop is left inside, or a wrong eye is operated upon, a long limb is operated upon. Coming to medical, I have to give transfusion to 2 thalassaemic patients and the blood gets mixed up. So that would be act of commission. So every act that we do is judged on whether I did it properly, which was required in that situation for a normal doctor or not. And of course, very important, the documentation is also seen. So I may have done 100 things right, but I never documented anything. So it is said that if it is not documented, it was not done. That is what the court of law will think. So you have to document everything in sequence with proper chronological order, with proper clinical notes, with proper legible handwriting of orders given for the management of that patient and what happened, what did not happen, what was the end result. Everything has to be documented because that case paper is what is scrutinized by the court of law. So negligence by base of 2 things, act of commission, act of omission, is what decides the fate of a doctor. What does not constitute medical negligence? If a medical professional acted in good faith to save a patient's life in an emergency situation, they may not be considered negligent by the court of law. Giving an example, a child has a head injury in school. He is brought by the school authorities to a doctor. CT scan is showing a huge bleed with fracture with movement of the center, the shift of the midline, and he has to operate immediately as a burr hole to decompress that hematoma. He does it because he does it in emergency without the parents being present for giving consent. And if the parents come and say, we were not there, how did you operate on my child? So it will not be judged as a medical negligence because he acted in good faith to save the child. So any emergency you can take, whether a patient has come with acute abdomen, he has a burst appendix, he needs to be operated, otherwise he'll get peritonitis, and the doctor operates without the consent of the closest relative or a parent, he will not be considered medical negligence. So this is an important definition for us. Also, we enjoy a therapeutic privilege of difference of opinion. So in management, if there are 2-3 doctors involved of different specialities, and they have a difference of opinion in the differential diagnosis, in spite of that, a reasonable degree of care is given to that patient for the most likely diagnosis, it will not be considered as medical negligence. And lastly, if there's an error of judgment, is not considered negligence. So of course, it should not be totally sideways or off center. But suppose it is a case of typhoid, but in first 2 days, it looked like malaria with a spleen, fever, and I gave an anti-malarial. So that is not an error of judgment. It's not a negligence because the typhoid, the disease takes times to evolve. And even the blood tests do not come positive in 48 hours. So if there's a complication arising out of typhoid within 2-3 days, and I'm not able to know that this is actually typhoid because there is no corroborative lab test or anything, it will not be considered as a negligence. So there are some silver linings somewhere. Now, 3 new bills were passed by both houses of the parliament, which came into effect on the 1st of July 2024. So it's not even a year now. So IPC has been completely replaced by the Bharatiya Nyaya Sanhita 2023, which is now known as BNS. The Code of Criminal Procedure is now known as Bharatiya Nyaya Suraksha Sanhita, and the Indian Evidence Act is called the Bharatiya Sakshya Adhiniyam or the BSA. Now, in the IPC, unfortunately, we doctors are happily ignorant about the laws existing previously and even now. IPC did not have any dedicated section for medical profession. There were 1 or 2 laws which were extrapolated to us. I will tell you which are those. And we were either arrested or we were charged for murder or we were having imprisonment or a fine. So there was no dedicated medical profession clause. Now, Bharatiya Nyaya Sanhita has a dedicated medical clause, it is 1061A. IPC only had a list of offenses and what is the punishment for them, like theft and other things. Now, Code of Criminal Procedure was what dealt with what punishment the police will give you once the offense has been, considered. So that is now the Bharatiya Nyaya Suraksha Sanhita, BNSS. It has one very important clause for us, which we will see. And the Indian Evidence Act or the Bharatiya Sakshya Adhiniyam does not have much for the medical profession to offer. So what's out? The IPC 1860 is out, which had 23 chapters and 511 sections total. And here there was one act on negligence, which was rash and negligent driving, which causes harm or death. And that was extrapolated to us as negligence causing death. What is in BNS 2023? 20 chapters, very concise, with now sections of 358. But there is an increase in punishment, there's an increase in fine, and there is a dedicated clause for medical negligence over here. So that is what we have to be aware of, which we should read. It takes time to understand. I mean, I'm still reading the 3 books. So it is part of our curriculum or medical education, you should say, the way we read our pediatric books or the other specialties, read their books and keep themselves updated with CMEs, workshop, conferences. Unfortunately, we doctors are not bothered about updating ourselves about the medical negligent acts, which can put us in a tight soup if we have a wrong, we are on the wrong side one day. In the new BNS, the offenses against women and children are now consolidated. So they were scattered throughout in the IPC. But in the new BNS, they have been consolidated and they have been stepped up in the index on priority in chapter 5. Also, a child is now for the first time defined as a child less than 18 years. Otherwise, various people had their own definitions, 12 years, 14 years, 18 years. But now a child is properly defined as 18 years. It is BNS section 106, subsection 1, which is applicable to a registered medical practitioner. This terminology of RMP has been introduced for the very first time in medical negligence laws, which says that you have 2 years of imprisonment and fine. Earlier, it was just either imprisonment or fine, but now it is both. The section 1062 is not implemented yet, and this is the one which deals with the the rash and negligent driving, which causes death. And then there was some counter action on it, so it has been suspended for the time being. But 1061 applicable to an RMP is in place. There are no cases as yet which have reached the court of law. So there is no precedence to say about what will happen to an RMP in such a situation. So there are no examples to give as such. The other BNS section is 117 subsection 3, which says that there is stringent punishment for grievous hurt resulting in a vegetative state or permanent disability leading to 10 years or life imprisonment. Now, this is a contradictory part, that for a grievous hurt, you get 10 years, but for death, you get only 2 years and fine. So, and there is one more hitch in the coming slides, which we will see. I will focus on 3 BNS and BNS sections, which should be understood today by all of us, and that would be enough for me to succeed in my lecture today. BNS 1061, which replaced IPC 304A, only applicable for death while performing a medical procedure by an RMP, which is now equal to a rash negligent act. And as I said, it is 2 years imprisonment plus fine. It had become 5 years imprisonment and fine, but with the intervention of the Indian Medical Association and their persistence, it has been brought down to 2 years imprisonment and fine. BNS 117 subsection 3 is stringent punishment for grievous hurt resulting in vegetative state or permanent disability, 10 years to life imprisonment. So here is a contradiction. If there's death, it is 2 years and fine. And if it is a vegetative state, permanent disability, loss, disfigurement, it is 10 years to life imprisonment. BNSS 173 subsection 3 has introduced preliminary inquiry for the procedures in criminal code, mandatory before any FIR is lodged, a very important section for us because it will help safeguard us before any police come as with an FIR to arrest us. But then there's a hitch over here, which we shall discuss here. So remember, earlier it was IPC 302 murder charge on us. So the example of Dr. Acharna Sharma in Rajasthan a couple of years ago, the gynecologist, where a mother died. And then there was a mob outside her house and they had brought the police and who charged her under 302 murder. She panicked and she committed suicide. So this 302 is no longer applicable to medical profession. It is now BNS 103, which is a bailable offense. IPC 304, which is culpable homicide not amounting to murder, was a non-bailable section, but under the BNS 105, it is a bailable offense. So this is a silver lining again for us. IPC 304A, which was applicable to us with rash and negligent act during driving, is now completely changed to BNS 106, dedicated to medical profession, that is bailable offense, 2 years in imprisonment plus fine. Now, when I spoke about this preliminary inquiry, I will tell you what is the hitch about it. So BNS 106, if you see that death by any person doing any rash or negligent act not amounting to culpable homicide shall be punished with imprisonment of either 5 years, which has now been brought down to 2 years, and also liable to be a fine, but it is while performing a medical procedure. And for the purpose of this subsection, the registered medical practitioner has come into existence, meaning a medical practitioner who possesses any medical qualification recognized under the NMC Act of 2019 and whose name has been entered in the National Medical Register, the State Medical Register. 1062 is not yet applicable. So what are the unanswered questions over here? What about medical negligence when the resulting death is not what about, if there is no death, there is a medical procedure, but there is permanent disability, it will not come under criminal law. What about death occurring due to rash and negligent act by an RMP in conservative management? There is a death of the patient, but the doctor is not charged. So will it not be covered under the criminal law? And should the medical practitioners who are not registered with NMC but with their own council registered, like Ayush doctors, dentists, interns, what happens to them if they have committed some medical negligence? What is the punishment for them? Is it 5 years or more? So that is not yet spelled out. And like I said, there has been no case precedence as yet in the court of law. We have no answers for the time being how this can go. So even if there's no criminal case lodged against the doctor, there can always be a civil case lodged against the doctor. Now, the BNS section, which I said about hurt and grievous permanent damage without causing death, this is dealt under BNS section 114 to 118, of which 117 subsection 3 is a stringent punishment in case of permanent disability or a persistent vegetative state. So what happens, suppose a child is born with severe birth asphyxia and he's a case of CP. Is that doctor or that gynecologist and the neonatologist under this section? Will you get 10 years to life imprisonment? We do not know as yet. And BNS section 125 is endangering life or personal safety of any patient, whether it of any person, which can be applied to even doctors. Wrongful restraint and wrongful confinement. So there is BNS section 126 where you cannot restrain a patient. You cannot confine a patient, 127 BNS section, on the grounds of non-payment of bill. And BNS section 130131 where a patient cannot even be touched without consent. So these are some of the clauses in the BNS section which we need to know and which can be applied to us if we are ignorant about it. Murder on medical negligence, like I said, IPC 302 does not apply to us in medical profession, but it has now become BNS section 103. So we are exempted, thankfully. BNS section 105, which was a culpable homicide not amounting to murder in IPC and involves 10 years of imprisonment. We do not come under this act also. BNS section 106, death by negligence. I'm repeating again, 2 years imprisonment plus fine. In forgery and cheating, these are the sections which can be applicable to us, especially because we have documentation which could be electronic or digital records. So if we have false documentation, we can be liable for action under section 2. BNS section 234, issuing false certificates. So be very careful when you issue any false certificate. Do not consider anyone your close friend. That very close friend can get back to you and put you in court. No signing and no issuing false certificates. So there's no friendship when you're a medical doctor. BNS section 335 and 337, making a false document like a medical fitness for your close friend, family members, a fitness certificate for rest. Suppose something goes wrong and that patient actually dies and you had given a fitness certificate, then you will not be able to prove yourself in the court of law, because everywhere the documentation and proof is required if you want to substantiate your statements. BNS section 318 and 319 is cheating, where it can be that you do not declare your actual degrees on the board or you do not rightly display your recognized qualifications. That will come under cheating. There are a few other important laws which we should know. That is not notifying certain diseases which can spread and cause endangerment of life to other people. Two notifications that I know is, one is TB. So TB comes under a communicable notifiable disease and you are liable for penalty with imprisonment and fine. POXO cases are the other ones which you have to notify on 100 or 1098 immediately when you come to know about it. Otherwise, you can be imprisoned for 6 months. The other sections are BNS section 272, which is malignant act likely to spread infection of disease dangerous to life. And BNS section 273, when you do not quarantine, you do not follow the quarantine rule, so you can be penalized for it. Some of the good acts for us to save us. These are you can take a snapshot or screenshot, but it requires to be read, reread, perhaps a printout to be taken and kept in your, on your board, so that then there are certain laws which can protect you if you have done something under good faith for the benefit of a patient and to prevent further harm. So these are some of the laws which we can read, understand, and remember that we can use this as a recuse to help us in the court of law. Now, sir has already told you three cases where, these laws have been passed by the Supreme Court and they will continue to protect us. One of them is the Jacob Matthew case, where independent and competent medical opinion for testing the reasonably competent person. So nobody can arrest you, nobody can harass you, nobody can file an FIR against you unless a committee is set up who will judge you on your competency of act of commission, act of omission, and your reasonable skill. So independent, competent medical opinion has to be sought, but higher the degree of negligence or gross negligence, it will be attributed to criminal liability. And like I said, the benchmark is always absence of average standard of care. We enjoy a therapeutic privilege of difference of opinion and an error of judgment. So there are 2-3 cases which Sir has already said. They are available online in detail and in brief, which you must know. So Lalita Kumari is that there should be a medical negligence case. Should there be, you have to have a preliminary inquiry. This is what is there in the BNSS section 173, which I was telling you. Now, the problem here is it is applicable. It is written in red here. This clause is applicable of preliminary inquiry in cases where the punishment is 3 to 7 years. And what is our 1061? 2 years imprisonment and fine. So unfortunately, this BNSS does not help us in the 1061 where there is death due to medical negligence during procedure, because there the punishment is 2 years. Whereas the BNSS preliminary inquiry can be done in cases where the punishment is 3 to 7 years. So here we have lost it and we are back to the pavilion. We are nowhere. So the new laws are not really so rosy for the doctors. Perhaps the noose has only been tightened further in our necks. But you have another silver lining. If the police have unnecessarily harassed you or put false charges of offense against you, you can have a counter filing of case against the police, which is under BNS section 248 for filing false charges of offense. And you can initiate proceedings against the police sections 195, that was the criminal code where you have BNSS 215. So the Bharatiya Nyaya Suraksha Sanhita will come to your rescue in these two sections, 215 and 279, in case someone has framed wrong charges, false charges against you. I'm reiterating my 3 clauses, my 3 BNS sections, so that it is etched in your memories. BNS section 106 deals with medical profession, where there is death by medical negligence during a medical procedure. What happens in conservative cases? What happens when there was no procedure? Nothing is known. We have to wait and watch. It's punishment of 2 years with fine mandatory. It is a bailable offense. So take some heart now. BNS section 1173 is stringent punishment for grievous hurt resulting in vegetative state or permanent disability. Be careful of this. Try to avoid such situations. There may be many examples of this. The grievous hurt is never intentional. I'm sure from the doctor's side, it may be unintentional or accidental, yet the patient and their relatives can put you in court. And the last is a BNSS section 1173, where I said that there's a preliminary inquiry mandatory for any prior FIR to be lodged. Nobody can arrest you, so do not panic like Dr. Archana Sharma. You have various laws to help you. Plus, here the preliminary inquiry is by a competent committee who will judge you. But this is for the offenses which have punishments of 3 years to 7 years. So the 1061, the death clause does not come under this BNSS. So summary, what doctors should know, what doctors should do, according to me, ignorance of law is not an excuse. I have bought this set of 3 books. I'm trying to read and understand them. This is also available online. Please do read it. Be aware of the basics of medical legal issues. Learn to prevent it. So prevention is always better than cure. But here the prevention is always better than the law. Documentation and record keeping is topmost priority for us. Read the BNS, BNSS, and the BSA. Please read the NMC Regulations 209 Professional Conduct, Etiquette, and Ethics. It is mandatory for us. Meet the local police, make them aware of the laws, ask them to put it up for themselves. So this is important because in case of any situation which arises, if you already know the police authorities, you have explained to them what are the laws which protect you, they cannot come directly to the mob says do an FIR, go and arrest the doctor from the house, from the clinic. They cannot do it. So if you have made them understand this prior, it is going to help you. So a group of doctors could go and do that to their local police station, not necessarily individual. So a group of doctors who are practicing in that area could meet the police. And it is important that the police hands over these notices or knowledge to all the local smaller police stations under them. So one day, hopefully, the entire police force will learn to pay heed to these medical laws for the protection of doctors. Thank you.
Thank you so much, ma'am, for that wonderful update. Really very useful, and I think we have to. It's an eye opener for many of us, including me, on what we have to know, what is important. We have to keep ourselves updated regarding these laws because they govern us, and we have to fall in line with them and also understand how to use them appropriately. Now, I'll request uh, uh, the members to ask any questions that you have. 1 or 2 questions may be possible.
There are no questions in the chat box, but sir, I have a question to Dr. Hemant sir. So you
Yes, sir.
told that the financial compensation can be given. That the court says that should be documented uh, in cash or check when some death occurs, right? So you told about the police, and the final thing will be the financial compensation, right, sir? So is that accepted, sir?
See, whenever these things are there, when you are going for the settlement, the terminology is known as a consent term settlement, where advocates of both sides agree on some terms and conditions, and that terms and conditions are to be notarized, preferably to be written on a stamp paper, notarized, and it can be done in front of the court of law also. So this thing can be done. But in the case where there is some offense which is not possible, so there it cannot be done. So this is possible, this is acceptable. But only one thing is that the draft of the whatever the consent term draft should be very well prepared. Otherwise, most of the time, because this is live streaming, so not to say more, but you should mention in that draft that everything was done. They don't have any complaint regarding the treatment, the pattern followed, and after that, writing that they will not go to other forums also after this term after this settlement, as well as on humanitarian ground or the moral ground, we are giving so much this thing. Amount wishes one if one wishes to mention can mention, otherwise need not mention also. So that works on the both advocates signing as well as witnesses from both these sides. Most of the time, the witness from the complainant or the litigant side should be the one who are the decision makers, and that signed signature should be there.
Thank you, sir. And Bella ma'am, your presentation was excellent, and you have concised whatever we have to spend days together with the BNS, what I say, whatever may be the chapters you have concised and whatever there. And it's that very informative one. And what this child mentioned, the child is less than 18 years, and the various things and good faith forms also, we have taken a snapshot of that. I can share it with all my members. Thank you very much for that, madam. And my question to you is, has any judgment come with this new BNS Act which has been implemented after July 1st, madam?
No, sir, not that I'm aware of. And I would put that question to my seniors like Dr. Gangulia and Dr. Mahesh Baldwa, who actually practice law. I mean, yeah, Mahesh Baldwa sir and Satish Tiwari sir, they are not into actual clinical practice now, I think. They are doing only law. There is Dr. J.K. Gupta, who's our chairperson, and many other people, members who are there. They are degree holders, LLB and masters. So they would know actually whether I don't think any precedence case has come in the last few months. You know, the Supreme Court hearing, what we say. There may be something lying in the court which will come up, and then they will be, judged as per the new BNS law, perhaps. So then we'll have some precedence case to discuss about what has changed from IPC now. So as of now, I am not aware of any such thing. But yes, there are a lot of medical complaints. There are a lot of police complaints lodged as usual for, medical negligence against doctors. And usually a local committee gives their report. And if the parents or the patient's relatives are not satisfied, then they go to a high court and Supreme Court. So that we have to wait and watch.
So to add to that, we don't have any judgment regarding that. But to see whatever some things were raised by Dr. Bela Madam also, and many of the medical legal talks, they say this related to the grievous injury. But one should be always, whatever they see, whenever we reply to any notice, or when we give our standings, it should be very clear, and the basics should be clear, because these case laws are always dynamic. They change with the things. What we should write is that whatever we have done, it should be as per the standard protocols. One thing. Second, whatever the sections related to this is my interpretation, because recently when I was at Gwalior, I had very strong debate with one of the famous medical legal expert, Dr. Neeraj Nagpal sir also. So what I say, what is my personal interpretation, because interpretation varies by the court of laws. You must have seen that the judgment which are given in the lower court often gets changed when it goes to the higher court. So because the interpretation changes. So as far as the grievous injury goes, what I feel, we are giving the treatment. As doctor, we are treating. We are not using the weapon which is dangerous weapon. One thing. Second, we don't have any intent of damaging the others. So probably that will not apply. That is my interpretation. But of course, the interpretation comes whenever there is a arguments in the court of law by both respondent as well as the defendant, and then the what court interprets. So as far as possible, we should avoid that thing. And one more thing regarding FIR. Most of the doctors, we feel that FIR could not be lodged. Yes, there is a statement in the Jacob case laws and everything that FIR should not be, but FIR is a right of every Indian citizen. So FIR can be done, but they will not act on the FIR because of the Jacob Matthew case law, as well as the Suresh Gupta case law, as well as her Kushum Sharma case law. Unless and until the prima facie of medical negligence comes by the committee of doctors which are appointed on that case, then only they will act. And therefore, of course, arrest is not there, and definitely arrest is not there. So we should not get afraid of that. One more thing I want to say, whenever because we as a doctor we get panic. I have seen, because I have gone through all these case from police station to judicial first class magistrate to the session courts to the high court to quash the charges which were before going under the trial. I have gone through all these stages, so I know practically. We should not get afraid. Even well-known, concerned, well-read lawyers, they get just perspired in the court of law. The basic remains, whenever the things happen, you just contact a person who rely on you and who you rely, maybe the good criminal lawyer, good medical legal expert, because most of the times when I get the call, they are most of the time they're given already the statement. Once the statement is given, nothing can be done. So before giving any statement to any appropriate authority, one should always ask what things to say. One more thing, one should never show. As a doctor, we are always in the habit of showing ourselves. I know this, but I don't. Never show these things in police station, in the court of law. Whatever they ask question, answer specifically. Answer specifically to the point of right. Don't make the things all things in detail. So these are the few practical points, and one clear point is that one should not get nervous, one should not get afraid, should immediately call what can be done, we should think of. And whenever you go to police station or whatever, you should always take one good friend of yours or good lawyer with you. Don't worry about that. And if they ask statement, it is just a, and see, for that matter, if anything happens, don't worry, it will go for 10 to 14 years. The judgment which came in my case was after 12 years. But the stress strain which is there, one has to able to. And there are, because as a doctors we don't get, so there are 4 or 5 incidents of violence also in our district place, where doctors, everything they did FIR, but after some time they compromised. I think so basically we should not compromise, and unless and until there's gross problem or loophole, then only one should go for settlement.
Okay, sir. Thank you. Thank you very much, sir. So the few takeaway points we have understood that every patient is a potential litigant. So that's one thing which we have understood. And the other thing is we should be expert.
Sir, 1 minute. We should think themselves a portal litigant, but at the same time, we still, I feel medical professional good one. We should give that also the faith or the whatever the
Yeah,
patient,
definitely.
and we
So
should
we don't.
practice accordingly. But
Yes.
thinking that in the back of the mind,
Yes, and we should be a medical legal like we should have some idea on on some medical legal like laws and those things, because our nearby police station people will not be aware of all the laws, and we should be able to advise them or like show them what are all available. And as you told, you if you can send me that what are the procedures, like what are the laws which are applicable, we will be able to send to all our members so that it can be put up in the notice board of all the clinics, sir. And we should have a contact with or the branch should have a tie-up with some medical legal expert and a criminal lawyer who will be able to should have a task force also with our branch. So these are the various things. Even though we cannot be, because we are not experts, we cannot be experts in all the criminal laws and courts. At least we should be aware of these things. Thank you very much, sir. Thank you. For my sincere thanks to Dr. Hemant, sir, for sparing your late evening with us and enlightening us. And this is available in our YouTube channel also, because few people have seen that, and that will be permanently available. And I share the link in our main official group also, so that people who have missed will be able to view it later. So that will be informative. And thank you, Bela ma'am. After your long drive back home, you are, sir, any comments, sir? Devendra, sir?
Yes, sir. Sir, first of all, congratulations, Dr. Hemant sir and Bela madam. Wonderful presentation, really eye-opening. And one query was there. I don't know, just this is the matters. That's why I'm asking. Suppose someone comes to my clinic and he has got himself the child registered for that to show me, and they're waiting outside, and then the child aspirates there, and but the parents do not know well, and they are coming to my chamber, then bringing the child. The child is dead. So what is my responsibility?
Sir, they will see whether you were well equipped to resuscitate at that time.
No,
You had a suction. No, child was brought, but aspirated, no, sir. What you did to do CPR or revive, the end result doesn't matter. He may not be surviving, he may not be revived, but what you did, you had an oxygen, you had a suction, you could do a bag and mask, you could do CPR, you had an adrenaline with you, IV line access you could get, whatever you could do. So if it is a short duration and you could do something, it's different. If the long time has elapsed and you could not do much, okay, then it's okay. You have to rather this is handed over to police. You do not give a medical certificate. You do not give a death certificate. It is handed over to police to do the postmortem, and the diagnosis is as per the postmortem.
So we should advise them to take the child where they should go then for our
You call the
safety.
police, sir. You call the
should.
police. They cannot take up the body.
We
You
should
will
call
call the
them.
police. They will come there, do an EPR, then they will take for postmortem, and then they will hand over. You cannot let them just take away, sir, because they will need a medical certificate at the cemetery or for the last rites. Every cemetery asks for the certificate.
Okay. Thank you very much. Thank you.
Sir, just to add for that, so our reception counter should be very well alert to identify the serious and the emergency patients. We should not keep them waiting, one thing. Secondly, many times it happens in our pediatric OPD, high grade of fever, they are sitting in the OPD and after half an hour they throw convulsions. That happens many times. In my OPD, there is almost lot of rush is always there. So their waiting hour is almost 1 to 2 hours. So it can happen. So is the reception counter, we should be well worse with this situation. So if high grade fever is there, they see the temperature and if any patient says, see, for that patient that is an emergency. For us, it may not be emergency. 102 degree, it may not be emergency for us. But it means if parents say, if they say insist on, best thing is just to train our staff to identify, take temperature, give plain paracetamol, and just get examined in between to alleviate anxiety and everything. So that works. Same thing, this 5 P's what I said. If they come in the rush period, generally it happens at our place. I do not above. So if they come, let us make by breaking the queue, let us examine them and finish it off. Then make it comfortable for them also and to also because there are people who just keep on asking questions in the reception counter, the waiting area. So that should not happen. And in
So, sir, it is triaging. Basically,
yes.
a triaging.
So
where someone knows
yes.
there is a serious child in the line.
So in your case,
and
what
that
is
child
said?
is managed earlier.
So in your case, what is said? If the patient is settled one and on feeding, it got aspirated, immediately the reception was noticed to be brought to you, and as madam said, to be done whatever is possible to document properly and informing the police the best option. Do not give the cause of death.
Yes, sir. Thank you, sir. Thank you so much.
Okay.
Thank you, ma'am.
So thank you, ma'am, for like after your long day's work and your long drive in the traffic, you have spared your time to enlighten our branch members. Thank you very much, and thanks my branch secretary, treasurer, and all the EB members and our president elect who have joined in this forum, and all the delegates who have attained the knowledge and logged in and attained the knowledge. Thank you very much for yet another excellent session, sir. Thank you very much. Good night.
Thank you. Thank you so much, sir. Thank you.
Thank you, sir, for inviting us. Thank you.
Thank you, sir.
Very much.
Thank you.
Good
Thank you
night.
so
Good
much,
night,
sir.
everyone.
Yes, good night, madam. Good night.
Good night.
Thank you.
Good night, sir.